These are your real estate closing documents explained. In a closing, you have a buyer and seller, of course, and they sign different documents. The seller signs fewer documents than the buyer does, so we'll dive into those first. The seller is going to have to sign the conveyance documents and whatever documents are necessary to convey clear title and fulfill their obligations under the contract. So typically in a North Carolina real estate closing, the seller signs the deed, which could be a quitclaim deed, a special warranty deed, or a general warranty deed. If you're using the standard offer to purchase, it's a general warranty deed, and that's the actual conveyance document. It is the document that upon recording will make the property belong to the new buyer. It will actually transfer the ownership of the property to the new owner. The next thing is going to be a lien waiver, is what most people call it, but the form is actually called the Owner Affidavit and Indemnity Agreement. So if it's a typical residential closing with no work recently completed on the property, no lien agent appointed or anything for, a renovation or a new construction, then this is what the seller will sign. And the shortest possible way to explain this is the seller is saying that any work that's been done on the property in the last 120 days has been paid for, or nothing was done that needed to be paid for. And the owner of the property that's conveying is also agreeing to make sure any outstanding liens that were due to things that that owner had done are going to be taken care of by that owner, and that the new buyer will not be prejudiced by those or be obligated to clean up something that the seller had done. The next thing is going to be a marital affidavit. So this is a document where the seller swears to whatever their marital status is. And if you haven't been on the channel before and seen all about marital interest, this matters because it is important that everyone with an interest in the property signs the deed so that there will be nothing lingering out there. And in North Carolina, if you are married, unless you have done something to sever the marital interest, your spouse has an interest in the property that you are selling, even if you bought it before you were married. So the marital affidavit is you swearing to what your marital status is, and that way the parties involved will know whether you're married or not. If you're not married, you're promising that you're not married, saying that you're not lying about that. And then, of course, if you are married, your spouse will join in the conveyance if they have a marital interest. The next thing would be a non-foreign affidavit. And this is important for a couple reasons. One, so that the closing attorney knows they don't have to withhold any special taxes on the closing. If there's a foreign seller, meaning outside of North Carolina or outside of the United States, then the buyer may be responsible to hold taxes so that the taxpayer, the seller of the property, will pay the appropriate taxes on the property. So interestingly, that becomes the responsibility of the buyer. That's why the seller has to affirm their status as to whether they are foreign or not. Basically, the main thing is to know whether that person is a U.S. taxpayer or not. Again, because if the person is not a U.S. taxpayer, the buyer is obligated to withhold some of the seller's funds so that the taxes can be paid to the U.S. government for the sale of the property. The second part of the non-foreign affidavit is that it's a solicitation for the taxpayer ID number so that the closing attorney can file the appropriate document with the U.S. government. So we're obligated to file 1099 or a certification for no reporting of 1099 for every real estate transaction we close. And that's whether you as a seller have to pay taxes on it or not. So even if you're like, well, I shouldn't have to pay capital gains, why do I have to get a 1099 or whatever it may be? We don't have any say on whether you have to pay taxes or not. We just have to fulfill our obligation to the U.S. government, which is to provide your taxpayer ID and that you sold property in a certain calendar year. So that non-foreign affidavit also serves as the solicitation for the taxpayer ID number. If you refuse to provide it, there are penalties. So the U.S. government has statutes that says penalties can be imposed for failure to provide the taxpayer ID so that this obligation can be fulfilled. And then the next big thing that the seller is going to sign is the closing statement. And this is the one everybody cares about the most because it's the dollars and cents. So it shows what the seller is owed for the property, any deductions being taken for commissions or unpaid taxes or invoices that need to be paid, any revenue stamps, whatever it may be that's needed to fulfill the obligations of the contract. And then finally, what the seller will receive upon the closing. So there may be some other seller documents that come up, but those are the main ones that a seller will sign at the closing. So moving on to the buyer. The buyer is, of course, going to sign a closing statement as well. If there's a loan, this is going to be called a closing disclosure. there's not a loan. It could be called an Alta settlement statement or a HUD, which is what it used to be called, but that form can still be used sometimes. And same thing, this is going to show all of the accounting of the transaction and ultimately the amount of money the buyer had to wire to the closing attorney so that they could close. Next, if there's a lender, then there's going to be a promissory note, and that's the promise to repay the money. And this is usually a shorter document, 3-4 pages, and it's going to tell you the loan amount, the interest rate, when payments start, how frequently you repay, if there are any late fees, and then you're going to sign that, and it's essentially, hey, I'm promising to pay the lender this money back. And then as a companion to that, in North Carolina, you're also going to sign something called a deed of trust. It's much longer. And I always say at the closing table, this is, it takes a long time to explain this or too many pages to make this point. But that document drills down to if you don't pay, you don't stay. And it's how the lender gets their right to foreclose if you stop making your payments on the note. And there's all kinds of restrictions in there about what you can do with the property, and not necessarily can you have chickens, can you not? It's more so restrictions about you have to keep the property insured. Don't do anything inherently dangerous that would, like blow up the property and get rid of our security interests. Because remember, the lender is lending against a, completed home that's got some value to it. And if you lay waste to that property, then their security interest has been diminished. So the lender does have a vested interest in making sure that the property stays in good condition. You're also going to agree in a document like a deed of trust to not get any other liens on the property that could jump ahead of the lender in line for foreclosure. Now that document gets recorded at the Register of Deeds. When you pay the loan off, it gets canceled at the Register of Deeds. But whenever you sell the property, you will have to pay off the loan. Now, the rest of the lender documents, I sometimes jokingly refer to them as the duh documents because they're not quite as legally intense as the note and deed of trust. These are things that you would expect whenever you're getting a loan from a property. For example, there may be documents that are telling you, here's your payment schedule. The amortization schedule is another way to say that. This is how you're going to pay your bill over time and how much money gets applied to principal and interest until eventually 30 years or whatever your term is later, the balance goes down to zero. So you'll see in a document like that how much interest you'll pay over time as well. And you'll sign your loan application. Now, yes, you completed the loan application at the beginning of the process, but part of the purpose of signing the loan application at the closing table is for you to verify the information you gave was correct, that you have not had any changes to that information that went undisclosed to the lender, and that you're promising you're not committing mortgage fraud, because that is something that the FBI comes after. That's not your local PD. So it's a really important thing that you've told the truth to your lender during the process about employment, income, etc. If you have an escrow account, which in other videos I have explained is a type of forced savings account for taxes and insurance, then there will be an escrow disclosure statement. And basically that shows you what the activity is expected to be in your escrow account over the next year. So you'll see how much money gets put into the account each month and then what disbursements are made each month. If you don't have private mortgage insurance, you may only see 2 disbursements. You might see one for insurance and then one for taxes each year. If you have private mortgage insurance, there will be a disbursement for mortgage insurance every month as well. You'll also be signing tax documents like a 4506C. I can't remember the name of the form, but another one that authorizes the lender to get copies of your tax transcripts from the IRS so that they can verify your loan application information was correct. And in these documents, you want to make sure that your social is accurate when you're signing them. I have seen in just one instance where underwriting was completed on the wrong person, and it wasn't discovered until the closing table when we're looking at these tax documents and I'm asking the borrower, make sure your social security number is correct before you sign, and she says it is not correct. And the lender was at the table and said, what do you mean? And she said, I mean, it's not correct. And it was discovered upon looking back at the loan application, oh, there's all these kinds of credit accounts on here that don't belong to this borrower. How it got to the closing table, not sure, but they were able to get it fixed the same day, miraculously. the borrower still qualified and they were able to close on the same day. But it's incredibly important that you look at the accuracy of your social, because underwriting and all of those things are going to kind of be looking at that particular social and the records associated with it to qualify you for your loan. So, of course, there could be different documents depending on your transaction, but for the most part, these are the closing documents that you are going to see at your closing, especially in a North Carolina law office. And these are the things that we see all day long, 5 days a week, 52 weeks a year, of what buyers and sellers sign at the closing table.